Hello, everyone, and good morning. I'd like to welcome you to the program on Achieving Justice and Equity through Litigation at the 2021 Albany Fall Conference. My name is Evelyn Gong, and I'm the founder of the Law Office of Evelyn Gong, PLLC. As co-chair of Albany's Government Service and Public Interest Committee, I'll be moderating this program. First, a few housekeeping items. The Asian American Bar Association of New York is certified by the New York State Continuing Legal Education Board as an accredited provider. This program has been approved in accordance with the requirements of the CLE board for a maximum of 1.5 credit hours, in which 1.5 credit hours will be applied to the areas of professional practice requirement. This program is suitable for both transitional and non-transitional New York attorneys. You must have pre-registered and confirmed for this program to receive CLE credit. The first page of the written materials that were emailed to you is an attorney affirmation, which you must complete and return to cle@albany.org. Codes will be announced during the program, and record the codes on the attorney affirmation. Please return your affirmation as soon as possible, within 1 week, so that we can send you your certificate. You received a link for an online evaluation for this session with the written materials. Please kindly complete the evaluation so that we can improve our programs. This program is being recorded for archival purposes. Your continued attendance in this program constitutes your consent to transmit, record, and use your voice and image for this purpose. And now it's my pleasure to introduce our esteemed and distinguished speakers. First, we are extremely honored to have Bill Lann Lee with us today. He was Assistant Attorney General for Civil Rights in the Clinton administration, and currently Bill's Senior Counsel at the Civil Rights Education and Enforcement Center, serving as Special Master in prosecuting civil rights actions. We're also very happy to have Stephen Wu as a speaker. He is Deputy Solicitor General in the New York State Attorney General's office. I'm also very pleased to introduce Lindsay Nako. She is the Director of Litigation and Training at the Impact Fund, where Lindsay represents plaintiffs in impact and class litigation. And last but not least, I'd like to introduce Christopher Leung, who is also chair of this program. Chris is a partner at Pollock Cohen, where he's a litigator and trial attorney working to protect the public interest. For more information about the speakers and their professional backgrounds, please refer to their bios on Albany's website for this conference. And now, without further ado, let's get started with the meat and bones of this discussion. I'd love to talk about impact litigation and some of the cases that you've worked on in your respective subfields. So I'm going to kick off the first question to Bill. For those of us who are not litigators, can you explain what is impact litigation?
Well, the term impact litigation is usually used to refer to litigation that has a planning element and is brought to affect social change. It's easier to give examples. Brown versus Board of Education for many years was thought of as the prototypic impact litigation. It's the case that ended mandatory school segregation in the southern states in 1954. A current example is the anti-Roe versus Wade litigation that's in the Supreme Court now.
Great, and this is a question for
Which is a bad thing mostly. But go ahead.
Yes, and this is a question for all of the speakers. Can you tell us about any impact litigation that you're working on now? Or alternatively, please tell us about some of your past work that was particularly meaningful or impactful. And Bill, I'm gonna ask you to go first again, please. Can you tell us about some of your cases?
Yeah, there've been a lot of them. So I'm going to focus on litigation against the Los Angeles Police Department. I left New York in the early 1980s and went off to Los Angeles and ended up heading the NACP Legal Defense Fund's office in Los Angeles. And we had a concern about the LAPD, which at that time was sort of a mascot for police misconduct. And I was going to talk about two cases, hopefully quickly. One is about an employment discrimination case, and the second is the Justice Department litigation about the Ramparts police abuse matter. Hunter versus LAPD was a case that the NACP Legal Defense Fund brought with the Mexican American Legal Defense Fund and a coalition of groups representing African American officers, Latino officers, and Asian officers through the Korean American Police Association. This case concerned about denial of promotions to the important middle-level jobs in the LAPD. The problem was that there was an imbalance, and you didn't see too many minority officers in lieutenant, sergeant, detective, or other decision-making jobs. So we brought the case under Title VII and the Employment Discrimination Act from the 1964 Civil Rights Act. And just to short circuit things, we ended up getting a resolution with a lot of goals and timetables. And the purpose of this litigation was to integrate the LAPD, because at that point in its history, it did not have very many minority officers, and the other objective was to get them into decision-making jobs. Okay, fast forward about 8 or 10 years later, I was Assistant Attorney General, heading the Civil Rights Division of the Department of Justice. And the Department of Justice had been investigating for many years the LAPD, and not promotion practices, but use of force and other ways the police department was treating civilians. The Department of Justice has what's known as a pattern and practice jurisdiction. And essentially, the scope of that jurisdiction with respect to use of force is coextensive with all the issues raised by the Black Lives Matter movement in the more current period. And some of you may know something about Rodney King and issues of that kind, but the sad reality is police misconduct is a recurring issue, and the Department of Justice actually has the ability to bring cases, an unparalleled ability to bring such cases because of the subpoena power. And that ended up being a very long case. I pulled the trigger on that, I think in 1999. And the case went on for years after, and that resolved with changes in the in how the police department treated civilians in Los Angeles. The objective was always to, in both cases, was to deal with reforming the LAPD. The first case had to do with the strategy of trying to integrate the people who made decisions. The second one dealt more overtly with the kind of practices. And the remedies actually are pretty much the same now as they were back then. The problem has been that there wasn't litigation to implement those remedies.
Thank you for all of your service in fighting for reforms in that arena. And now, Stephen, I know that you have extensive experience in census litigation at the New York AG's office. Can you share with us a little bit about your work on that?
Sure, I'm happy to. So I can talk about two census-related cases that I've worked on in the AG's office. And both of them, through somewhat different means, actually accomplished a real-world impact, which I think is very rewarding for me to work on. So the first case was called Department of Commerce versus New York, and it was about the prior administration's attempt to add a question about citizenship to the decennial census questionnaire. As I think most people know, every 10 years, the Census Bureau conducts this really amazing survey of the entire country, where they try to count the total population of everybody living here. And they do so sort of unusually by getting actual responses from every single household. So it isn't, in fact, it's forbidden to be a statistical survey. They actually need some sort of response from as many households as possible. The principal way they accomplish that is by sending out a questionnaire, which hopefully everybody has seen and responded to in the last round. And then if people don't respond, then the Bureau actually sends out workers called enumerators to go to every household, sort of lay eyes on people and ask them in person how many people are living in each house. So this has been going on obviously since the founding. And one of the interesting features of the census process is that it has two purposes. One is to count the total population, but the other from the beginning has been to collect demographic information about the country. And for purposes of this discussion, it's important to know that those objectives can be in conflict. The more information you ask from people, the less likely they are to respond at all, right? Because people are busy, or sometimes there's what's called sensitive information, where people don't want to say something about their household, and so they'll just avoid a government-hired enumerator knocking on their door. They just won't answer them at all. And those objectives are sort of highlighted by the prior administration's decision to add, for the first time in the nation's history, a question asking about citizenship status for every household in the country. I think that there was a well-understood empirical research and history showing that asking people that question was a sensitive inquiry and that it would deter people from responding to the census. You know, in the Supreme Court, there's a really great amicus brief by Napaba and Aldef that sort of outlined the consequences of asking about citizenship, particularly for immigrant populations, where those populations are already very difficult to access through the census because of language barriers, unfamiliarity with the process. And then you add to that questions about citizenship status from the federal government, which is the immigration enforcer. And it's very understandable that people are hesitant to respond. I think part of that hesitancy also comes from these unfortunate episodes in the census's past where that information was misused. I think that one of the most shameful episodes is that census information was used by the federal government to identify Japanese American families for internment during World War II. And nowadays, there are supposed to be protections against that kind of abuse, but nonetheless, that's the fear that's already a major problem for reaching immigrant populations and is added to when the federal government comes around asking people, are you a citizen? Are you a non-citizen? What is your immigration status? So to cut to the end of this process, so we filed a lawsuit when it became clear that the department was going to add a citizenship question to the census questionnaire. We were able to succeed in the district court in blocking that question. And then sort of amazingly, the Supreme Court ended up agreeing that the question couldn't be added, although for a somewhat funny reason. They didn't do so because it would necessarily harm the census process or prevent the collection of data. But they said that the reason that the prior administration had given for adding the question was pretextual. In other words, it was a made-up reason that was not its true motivation. So the reason they had given was that they needed citizenship information to enforce the Voting Rights Act. And there's some facial plausibility to that because Voting Rights Act enforcement requires some analysis of voting age population and how you pack together or unpack different populations in different districts. But we got discovery into the department and into the federal government in this case and found just like amazing evidence showing that, in fact, the decision makers didn't really care about the Voting Rights Act, and that, in fact, they were motivated by something else, right? Something else that nobody talked about, that nobody would admit to. But I think everybody was aware, let's say, about the deterrent and disproportionate impacts of asking the citizenship question. And I think ultimately, even the Supreme Court agreed that the department had gone too far. And so they were not allowed to include the citizenship question. The census went through as originally planned. It went through a lot of obstacles because of COVID, but I think we were able to at least keep that question and its harmful consequences off of the questionnaire. The second case I'll talk about, I'll do this maybe more quickly, is a case called Trump versus New York, which was about congressional apportionment. So in addition to collecting total population information for other purposes, one of the major uses of population information is to determine how to allocate the 435 representatives in Congress across the different states. And so the more population that one state has, the more representation it will have in Congress relative to other states. And that's where you've gotten the news recently about New York losing 1 seat and Texas gaining 6 seats, that sort of thing. Again, historically, the way that apportionment has worked is by looking at the total population of each state. Like you just, like warm bodies, basically. You don't care who they are, what age they are. And importantly, the country has never cared about immigration status of the people living there. If you're there on census day, you are counted, and you are counted for purposes of apportionment. So again, this is a little while ago now, the Trump administration announced a policy where for the first time they were going to exclude undocumented immigrants from apportionment. And because different states have different population of immigrants and undocumented immigrants, and different communities have different proportions of undocumented immigrants, that policy would have the effect of basically depriving certain states and certain populations of political representation, right? Like you would have more people, like more undocumented immigrants in a city or a state represented by fewer people in Congress. And so we again challenged that policy, on the ground that it was contrary to the Constitution, in violation of like centuries of tradition and how to apportion seats in Congress. And a 3-judge court agreed with us on that theory. And when we got to the Supreme Court, it sort of resulted in this interesting, there's a sort of interesting endpoint here. So I'd like to think in part because of the litigation, sort of information started coming out about exactly how you would be able to figure out who was undocumented in each state. And there's a connection to our prior litigation, because if you are not able to ask about a citizenship question, right? And as people may know, there's no like central database of undocumented status in this country for obvious reasons, right? How are you supposed to figure out who's undocumented out there? And I think because of that, and because of various lawsuits, including ours, the Census Bureau and the Department of Commerce had started expressing internal concerns as well as public concerns about whether any of this could be done, right, at all, or in time for congressional apportionment, which has to happen right at the start of the new year of every 10 years. So when we got to the Supreme Court, again, the prior administration's defense was partly that they were allowed to do this, but partly they also said, it's early days yet, right? It's like 30 to 60 days before we have to do apportionment. And who knows if we're going to get this done? Maybe we can't. And the Supreme Court, maybe sort of like crediting the government's words, right? Basically said it's too early to tell, right? Like there's a lot of doubt about whether this process can happen. The Bureau is saying we can't find the undocumented population. Maybe it won't happen. And so they basically dismissed our case on jurisdictional grounds, in the month before the reports of the census numbers and the congressional apportionment. And the coda to this was that President Biden won the national election. He came into office and sort of immediately announced that the federal government was not going to exclude the undocumented population anymore. And so that turned out to, prove true the Supreme Court's prediction that maybe this whole thing wouldn't happen. But again, even though this I can't say with any certainty, I like to think that the litigation here, as well as the information we uncovered, helped to, shall we say, persuade people in the government at the time to like slow down the process and maybe question whether it was achievable at all.
That's wonderful. Thanks. Lindsay, can you tell us about some of the impact or class action cases that you've worked on or are currently working on?
Of course. It's so fascinating to hear about everybody else's cases, and I will echo a little bit of Stephen, the second case that Stephen was talking about. Last year, the Impact Fund partnered with Western Center on Law and Poverty down in LA, And we represented a class of food stamp recipients, SNAP recipients in California. And so we filed that case shortly after everything shut down for the pandemic. There was, in the first round of emergency COVID legislation, there was a provision for emergency food stamps. And so we found out relatively early on that the USDA had taken this provision of the legislation and had interpreted it to mean that emergency food stamps, increased food stamps, would be available only to households that were receiving below the current maximum amount of food stamps. So the way food stamps work is the lower your income is, the higher the amount of food stamps you receive, right? That makes sense because your home has less money to attribute to food expenses as compared to housing or other necessary expenses. So the folks who are already receiving the maximum amount of food stamps were the folks with the lowest incomes. And so USDA had implemented this formula to say, everyone is going to come up to the maximum. So that is how we're going to allot these emergency funds. So basically, the higher your income was, the lower the food stamp amount was that you were receiving. I mean, we're not talking about anyone who is, like high income, but if you qualify for the food stamp program, the higher your income is, the lower the food stamp amount you receive. So therefore, the folks who were receiving the most emergency funds were the folks who had, relatively speaking, the higher incomes. So we were able to represent the folks who were receiving zero emergency funds because they were already at the maximum. And that was just an incredible moment of responding in the pandemic. We all had just returned to our homes and we were dealing with rapidly processing the emergency legislation that was coming out of Congress and how the executive branch was implementing it. And so we were able to move very quickly and get the case filed. And then we went through about a year of litigation. We did not win a preliminary injunction, which we were hoping for. And we went up to the Ninth Circuit and we weren't able, the Ninth Circuit panel was not willing to reverse that. We had two recently appointed Ninth Circuit judges and the chief judge wrote a vigorous dissent in our favor. But vigorous dissents do not get food stamps to people. But then when we returned back to the district court and we had briefed our motion for summary judgment and we were waiting for a decision. Then we had a change in administration. And shortly after the inauguration of President Biden, the executive branch released a press release saying that they were going to be looking at this issue and that they were going to encourage the USDA to review its policy on emergency food stamps. And so then shortly after that, then we were able to reach a settlement with the agency that eliminated the application of the current policy in California. And then shortly thereafter, they issued a new policy that gave an equal amount of emergency food stamps to every household. It was, I believe it was $96 a month. It is still going on because the state of emergency still exists. And so there were only two cases filed on this issue. There was ours and there was one on the East Coast. And I do really believe, like Stephen said, do I wish we had won our preliminary injunction? Absolutely. But absent that, I do think filing these cases, if we aren't able to win in court, then it also means that we're flagging these issues for policymakers and we're telling them these are important issues that are affecting people's lives and you can also do something about it. So the fact that the executive branch, once the administration changed, jumped right into action to address the issue. I like to think, like you said, I like to think that our case kept this issue on the radar. And the fact that we were continually producing evidence of the impacts that people were experiencing as food costs were rising and supplies were being limited. I like to think that that made a difference. Do we have time, Evelyn, for me to talk about one other case or should we move on to Chris?
Maybe about 1 minute. Is that enough
Okay.
time about the other
Okay.
case?
So then the other case that I'll talk about very briefly is a case that Bill and I worked on together for a very long time, a case called Ellis versus Costco, which Bill filed in 2004. And when he and I started working together in 2007, I started working on the case. And it's an employment discrimination case on behalf of female workers at Costco warehouses around the country. It was a promotion discrimination case, having a lot to do with subjective evaluations and just the lack of objective hiring criteria. That meant that women were not getting promoted into warehouse positions for a lot of different reasons. And so the reason why this case just resolved, I think we finally paid out the settlement funds in 2018. So I worked on it for over a decade. So these cases can take a very long time. But the most meaningful part of the case for me was that we spent a lot of time talking to women who assumed that the problem was theirs, right? That they had a bad manager, or maybe they weren't ready, or maybe there was someone else who was, had a closer relationship with the manager. And to show the conversations that we had with the women who worked at these warehouses across the country and showing them the patterns of behavior and the data around promotion rates, we just had so many incredible conversations where women felt an immense amount of relief, realizing that this wasn't about them individually. It was about a system that was stacked against them. And so that piece of consciousness raising, I feel like, is a really critically important part of our work and part of the progress toward justice, separate and apart from what happens in the courtroom.
Thank you for telling us about your very important work. Chris, please share with us about some of the class action litigation that you've worked on against big bad companies.
Sure. Our firm has a series of class actions that we brought against manufacturers of baby food who are found to have left heavy metals in their products. That said, I guess one case that was actually particularly impactful and meaningful to me was a case that our firm brought against the FDA to try and remove menthol from cigarettes. Menthol in cigarettes has been a long-standing public health problem recognized by many groups. And I think back in 2009, Congress in particular, in passing the Family Prevention, Smoking, and Tobacco Control Act, identified menthol in cigarettes as particularly harmful not only to minorities, but also specifically to the African-American population. And in the accompanying report that went along with that legislation, Congress noted that it was particularly concerned with the historic targeting of African-Americans by companies with respect to menthol in cigarettes, the high rates of menthol use among African-American youth, as well as the disproportionate impact of lung cancer and other health problems within the African-American community related to menthol in cigarettes. And so the long and short of it is that, Congress recognized this problem way back in 2009. They had a committee report in 2011, which determined that removing menthol from cigarettes would improve the public health. In 2013, FDA came out with its own report, basically said the same thing, that menthol cigarettes are more addictive than traditional cigarettes, are more harmful than tobacco flavored cigarettes, that for people who are trying to quit, the quit rates are incredibly much lower, for example, for people smoking menthol cigarettes. And so when I came across this problem while at the New York Attorney General's office, it seemed like a great opportunity to try and sort of make a meaningful impact within this particular community. And so, we filed a case in the Northern District of California. Our case is in front of Judge Westmore. In reaching out to our plaintiffs, our clients, the African American Tobacco Control Leadership Council, the American Medical Association, and the National Medical Association, among others, you can just feel the sort of gratitude that people have, like, we're finally going to try and do something here. We're actually going to do something. And so it was incredibly gratifying just to sort of bring that litigation. And then also to sort of get past the motion to dismiss, which we were able to get past last year. Essentially, FDA basically argued that it was entirely within their discretion whether or not or when to act on menthol in cigarettes, despite the sort of prior findings of the agency. And so the sort of suggestion was that, yes, we recognize that menthol is a problem. We recognize that removing menthol from cigarettes would improve the public health, but it's in our discretion to sort of sit on this forever. And so we were able to sort of argue to the court that's not true. That's not the case. Certainly under the Administrative Procedure Act, any sort of federal agency needs to sort of move on a public health issue within a reasonable amount of time. And we felt and argued that, 10 years is long enough. And so the court agreed with us. And thankfully, we were able to get past that motion to dismiss, which is fantastic. Since that time, the Biden administration, which came into office earlier this year, agreed that by April of 2022, they would issue a new rule with respect to removing menthol from cigarettes, which is fantastic. They haven't set an implementation date, but as a result of that announcement, FDA is now arguing that the court lacks jurisdiction over our case, and is now arguing that all of our claims are mooted. And so we're in the middle of briefing right now to sort of try and resolve that for the court. And hopefully the court will still find in our favor that yes, in fact, we need to sort of continue this litigation. But that is the case that's been particularly meaningful to me and impactful to me.
Thank you. And so now let's pivot a bit and talk about the actual practice of impact litigation. I'd like to talk about your career trajectory leading up to the respective cases that you've handled. What led you to that sort of work? And so I'm going to direct this question to Bill first. Bill's a 40-year veteran civil rights attorney. And Bill, I know that you also have the distinction of having served as NAACP Legal Defense and Educational Fund, first as an assistant counsel in its New York office, and then as co-head of the organization's Los Angeles office. How did you wind up there?
Well, I've had an incredible career, to be honest, if I don't say so myself. But I'd like to talk about failure. I'm a product of the New York City school system. I did very well at Bronx Science. I went to Yale. And I finally got to Columbia Law School. And first year was a complete catastrophe. So I went to talk to a dean, and he pointed out that I actually had no experience with lawyers. I'm not sure I'd ever met a lawyer at that point in any way, in a meaningful way. So he strung me along and suggested that what he would do is get me a job with one of the faculty members who had a sideline outside of teaching. And so I show up in the NAACP Legal Defense Fund at the beginning of second year. I'm basically a reclamation project at that point. And I get ushered into the office of Jack Greenberg. Jack Greenberg was one of the people who argued Brown versus Board of Education. He was the only white lawyer on that team. And he was, when I met him, Thurgood Marshall's handpicked successor to head the NAACP Legal Defense Fund, which was, and in many ways still is, one of the leading civil rights organizations. So it turns out that Jack was looking for a research assistant because he had been honored by the Bar Association to give a Cardozo lecture. I'm happy to say this to this audience because you might even actually know what a Cardozo lecture is. It's something that's given to people who've done very well in our profession in New York. And I turned Jack down. I said, actually, I'm here because Dean Folsom thought that I should get some experience with real lawyers and real lawyering. So after that initial encounter, we agreed that I would be his research assistant and that I could work on cases at the Legal Defense Fund. This is in some ways a turning point of my career because what I ended up doing was helping Jack with his lecture, which became a case book, Judicial Process and Social Change. And Um, I ended up with a job at the NAACP Legal Defense Fund, which was very hard to get. And I ended up having a mentor. And maybe later we can talk about mentorship. But so out of that failure, that miserable time in first year law school, I ended up with, this 2-year tutorial, personal tutorial with, at that point, the best civil rights lawyer in the country. So you don't have to be smart, you just have to be lucky.
Thank you for sharing that very inspirational story. Stephen, your work at the AG's office directly impacts immigrants and communities of color. Can you tell us about how you came about doing that sort of work?
Sure. So my story is less interesting than Bill's, unfortunately. I did what a lot of young lawyers do when I was young. I went to law school, I clerked for a year, and then I went to a law firm, since those are the easy jobs to get afterwards. And then I was sort of required to think about, I was in DC at the time, and I was required to move to New York for personal reasons, because my now wife got a job here and said that we were going to move. And so I ended up looking around to see what was available. And I found the office that I'm in now, in part because of the work that it had been doing in impact litigation, other sort of like high profile cases, including the cases that Chris was working on when he was at the Attorney General's office. And so I applied here as just a normal line attorney. I did end up having a personal connection through somebody who I was working with at the law firm, which is how I found out after the fact that I got this particular job. But it was very much just like, taking a shot at the lowest level of attorney coming into the office. And then after I got in, I guess the other half of this that I'll answer is, how I got to work on some of these cases once I was in the office. And I think it was a combination of like starting off by, doing good work, and then sort of making yourself known to people who are making decisions about who works on certain cases. And in an office like this one, it's a political office, it's an affirmative litigation office. They're always looking for people to work on cases so they can build their portfolio. But I think the one thing I'll emphasize is I don't think that's enough, right? Like if you just do good work and you just sit in your office, people might come find you, but you sort of need to be flacking for yourself a little bit, right? Like looking for work here, asking for work, being a little bit of a self-advocate. And so that's part of what I did too. I just kept my eye on what was going on in the office. I'd walk around when you could walk around and talk to people. And I would just ask, I would hear about a case and I'd be like, hey guys, like I'm here. At the time I didn't have kids. I was like, I'm free, I can do whatever you guys need. And that's one of the ways that I was able to start working on those cases. And then it's just a snowball effect from there. Once people see you and recognize you as somebody familiar on a certain type of work, it's much easier the next time around to be like, oh, that guy, I guess you've seen him once before. Let's use him again. So that's how I got to work on those cases.
And Lindsay, what was your path going from private practice to the nonprofit world? Have there been any distinctions in serving communities of color between the two sectors?
Mm-hmm. So I spent the first 10 years of my career in private practice. In law school, I was very interested in Title VII class action work. That was really my passion. That was what I thought I was going to do. And then I found this small firm in Oakland that did employee benefits work. They did work with the Employee Retirement Income Security Act. And I thought, I have no idea what this is, but these people seem really kind and smart and generous. And they felt like they would be good mentors. So I said, okay, I'll do this for a couple of years and then I'll figure out, then I'll get back to Title VII. Lo and behold, Title VII came to me, like I said earlier, when Bill joined the firm, just a few years after I started practicing, bringing with him an incredibly impressive docket of Title VII class action cases. And so it was like my dream come true that I got to do this work with, I want to echo Bill's note about the importance of mentors. I got to do this work in the footsteps of people who were so experienced about the highs and the lows of the work, the challenges, the benefits. and who really prefaced first and foremost in all of our cases, Title VII and ERISA and others, really pursuing the righteous cases and doing work that's going to have some social good, that's going to have some impact, while also running a business. That was also what we were there to do, and we were able to do both of them quite well for a long time. And then the transition from private practice to nonprofit happened somewhat suddenly. In 1 year, I had my daughter and I was on maternity leave, and then I came back, and then we made the decision to close the firm that we'd been practicing at together. And so then things were chaotic. And so I just wanted to land in a place that felt familiar and where I could continue doing the work I wanted to do while I figured out my life. And so there was an organization that had been co-counsel on this case that I referred to earlier, Ellis versus Costco. And so I was able to reach out to our co-counsel and say, I think my pitch was literally something like, can you hire me for a year so I can finish working on Ellis versus Costco, and while I figure out my life. And so I'm very grateful that Jocelyn Larkin, the executive director, agreed to that scheme. And it probably, didn't hurt at all that Bill was on the board of the organization for a long time and is, and has worked with our executive director in various capacities for many, many years. And so that was, sort of a bumpy transition. I wish I could say it was, well planned and had been a long part of my progression, but it happened somewhat suddenly. But it still came back to that idea of I wanted to work with good people. I wanted to work with people who knew more than me, who were kind and generous, who were committed to the work, and who would keep teaching me. And so I was very lucky to find the landing place that I did at the Impact Fund, and it's been an incredible second stage to my career. So I'll take just a moment about serving communities of color. And I would say that I think in private practice, we have an obligation to be more intentional and thoughtful about it, because it can be so easy when you get those calls. I mean, we were a plaintiff side firm, so we were getting calls all the time by people who had been denied employment benefits, who had been denied a job. And so it's very easy just to look at that, intake sheet and pick the cases that seem like potentially the strongest cases and, serve individuals of color who had been disadvantaged in the workplace. But to think more, it takes more effort to think strategically and systemically about how the work we do attacks the continuing existence of racism in our society, and to be more intentional about building partnerships with organizations that knew more about what was happening than we did on a systemic level. And so I think we had to be more intentional about it and do work to find partners in cases and to bring other organizations in on cases we were working on so that they could lend their expertise to the case. And to really not just have them as, a name on the caption, but really to have them as a critical part of our team that informed strategy and the progress of our cases. I think that's much easier to do on the nonprofit side, because now we are all we all swim in the same waters. And I'm very lucky to have so many colleagues at nonprofits across the state and around the country that are, that their primary purpose is serving communities of color. And so, I think it's become a little bit more, I'm able to do it with less intentional effort at this point, which I think is a real, real blessing of this part of the work.
That's wonderful. Chris, what led you to work on the suit against the FDA to remove menthol from combustible cigarettes? And that's a case that highlighted the health disparities in the Black community.
Right. So, initially I was made aware of this sort of long-standing public health problem while I was at the New York Attorney General's office, where I was working with Stephen. The American Lung Association came in and basically wanted the state to sort of do something. And they put on a presentation about how, Congress and the federal government had an opportunity to address menthol in cigarettes back in 2009, the sort of, disparities that existed within the African-American community, And it just seemed like really interesting work, and it seemed like work that sort of was calling out for need to be addressed. And so when I left the Attorney General's office, it was definitely one of those cases where I thought, this would be really fantastic if I would be able to sort of get involved in here somehow. At the time, Scott Gottlieb, who was the FDA commissioner at the time, had sort of come out and announced in the year before, in 2018, that the federal government was going to be doing something. And so up until that point, until it became clear sometime in 2019 that the federal government wasn't going to do anything, I was just sort of sitting on it. But once it became clear that there was still this, public health problem to be addressed, I actually ended up going to one of the larger tobacco control public health conferences in Minnesota. And I met up with some friends over at the Public Health Law Center. As you might imagine, there's the meeting and the conference, and then there's the pre-meeting where, actual stuff gets discussed and people decide what's happening. And so I was lucky enough to get invited to the pre-meeting where Mitch Zeller, the FDA tobacco control guy, was going to be there. And, just sitting in that conference, it just seemed apparently clear that every single public health organization had menthol at the very top of their list. And they said, like, Mitch, what are you doing? This needs to be addressed. And so after hearing about that, I reached out to some contacts over at the African American Tobacco Control Leadership Council. They're based in the Bay Area, California. I reached out to them through a mutual contact. I was like, hey, I'm from California. I'm actually going to be in town, sometime in December, visit family. Do you guys want to meet up and talk? And so they invited me over to one of their homes for dinner. We talked about potential claims. We talked about what it meant to sort of like have them be sort of a partner in our litigation. And I think what particularly drew me to them was having a really strong advocate to sort of explain why it is and like why this is a problem within the African American community. It's, here in New York City, Al Sharpton is a very incredibly strong advocate for, his causes. And, in the past, he's certainly advocated for why it is that menthol in cigarettes is particularly important to the African American community. And so it's sort of like, there was this sort of conversation that we were really hoping our plaintiffs and clients would get involved in. And so in talking with Carol and Phil and Val, we felt that, they would be incredible advocates. We thought they had been in this space for a very, very long period of time, and that it would be really fantastic. And so they were excited. And we eventually ended up filing our case in and around Juneteenth, shortly after the whole sort of when Black Lives Matter was starting to kick up, and we're like, if now's the time to do this, now's the time we really have to get involved. And so after we got our case filed, it was sort of like, this is great. I'm so happy. I'm so glad. And so, sort of like, all right, let's get this thing. So that's how that sort of case came to be. But I guess, just sort of jumping back to law school, growing up in the Bay Area, I'll just say that, when you grow up with like Berkeley, that's so close by, Berkeley, the campus is being so close by, it's hard not to be aware of, the free speech movement, the Black Panther Party, and just sort of all this sort of social justice that's in and around the community. In law school, I had an externship with a former criminal defense lawyer. His name was James Larson, who apparently used to sort of help defend some of the members of the Black Panther Party. And so, having an externship with him was just like incredibly helpful just to sort of get things going. And when I actually did end up moving to New York, it turned out that he knew my future boss, Dana Beaverman at the New York Attorney General's office. They're part of the National Lawyers Guild together, and they knew each other. And so it was just sort of like a really incredibly helpful transition to help me.
Wonderful. That's wonderful. I'd like to ask all the panelists about the challenges of obtaining leadership roles. Bill, can you please share with us a bit about the presidential appointment process and how you became Assistant Attorney General? What were some of the challenges of getting appointed?
If you look at who has become Assistant Attorney General in Democratic administrations, and I have that caveat because it's in Democratic administrations that office can be more active. You will find that most of them worked at the NAACP Legal Defense Fund. And yes, I was the first Asian American Assistant Attorney General for Civil Rights, but I was also legal defense fund lawyer. And so I fell into a pattern that continues to this day. If you look at who has the job and where they worked before. So having the LDF credential was very important. Second, the civil rights groups play a kind of filtering role in terms of pressing administrations for putting in place people who can actually do the job and sort of know the field. And at the point that I became a nominee, I worked for the Legal Defense Fund in 2 separate times for about 17, 18 years. And so I was a lifer, and I had a lot of experience on civil rights cases. And as you can see from the Hunter versus LAPD case, I had a particular interest in coalition cases. And I did a lot of work with MALDEF over the years. And when I was in New York, I had a sabbatical period. So I was for 9 months at ALDEF. And my biggest accomplishment was hiring Margaret Fung. But you know, it's a political appointment. And so you would think that there were a lot of political considerations. I personally didn't find that much. I think in some ways I was a known quantity. Now on the negative side, I had the advantage of having spent all that time in California, away from New York. And the way the Legal Defense Fund was set up, the people who did the borking, which was the opposition to the appointment of Judge Bork to the Supreme Court, were all in the New York and Washington offices. I was this guy litigating cases in California, and I didn't have anything to do with borking. And the Republicans made it known that they were not interested in anyone who was involved in borking. So that was actually very interesting. It's just something I happen to be this, litigator and not anyone who testified in Congress about Judge Bork. Also, I was willing to accept an acting appointment. The civil rights groups thought it was demeaning if I accepted an acting appointment and not the full constitutional appointment. I had a more practical objective, which was I figured out that the civil rights groups would continue to press for my nomination if I accepted an acting appointment, which they did. So I was a perennial candidate, and there were actually demonstrations and and all these efforts underway while I was on the job. So it wasn't the case that I was just this acting appointment that people would just forget. I was actually in people's faces quite a bit in Washington. So, and the other thing is, I discovered that, well, I could talk about the Civil Rights Division later, but I would say that the most important thing was probably the coalition aspect. I wasn't just an Asian candidate. I wasn't just legal defense funds candidate. It wasn't that just that I was this guy who had done Latino cases and gender cases. You know, it was a combination of it all.
That's
So
wonderful.
if you want the job, I would try to get a job at the NAACP Legal Defense Fund.
That's wonderful. Thank you for sharing your insight on that. For those aspiring to a leadership role in government, Stephen, can you tell us about some of the challenges that you've witnessed as a government attorney?
Sure, and some of this echoes what Bill has just said. I think there are pros and cons of being in government in terms of getting leadership. The major benefit is that there is so much work here and not enough people that it's easy to get, in a sense, the opportunity to do work, right? There's very little like grunt work, you know, there's like, you're turning out in the pellet shops, you know, briefs by the week, you're showing up in court all the time. And so the ability to sort of make a name for yourself as somebody who does good work and is dependable and has maybe some insight that's special is actually quite large here. And that's maybe a comparison to being at a big law firm where, you know, I think the incentive structure is a little bit different. You know, there are some downsides here though, and it's very interesting hearing Bill talk about this. I mean, you know, I think one of the things that is true, especially true in government, is that it tends to be somewhat traditional and a little hidebound. You know, it's you can be a first in some ways, as Bill was, and yet nonetheless follow on the same line as like all of your predecessors, right? And I think that is that desire for some familiarity is a challenge in government practice. People want people with a certain educational background or certain you run in certain circles, and I don't mean the country club necessarily, but they run in certain past employment circles or certain case circles. And that can be an obstacle if you haven't broken into that area before. And then the last thing I'll say is that I think in government, especially for the highest level positions, they are political in the sense that Bill is talking about, which is they're not merit driven. There's only one position and like dozens and dozens of qualified candidates. And I think the way people get those positions is by having advocates out there who are not just happy to answer questions, but are really pushing for people. And that's not something I've done yet, but I feel like that's for the very highest positions that lots of people are angling to get. That's sort of the big jump that's needed for a government job.
Lindsay, can you tell us about some of the common obstacles to rising to leadership in the nonprofit world?
Absolutely. I think one of the biggest challenges is I think that leadership roles in nonprofit organizations require a skill set that is slightly different than what we do as lawyers. You know, to be a director of litigation, obviously I have to have a lot of experience with state and federal litigation. I have to be able to run cases. I have to be able to run case teams. But the further up you go in nonprofits, you also become, you know, a manager. I have to know how to, you know, how to hire people. I have to know how to run teams, not just case teams, but, you know, managing larger teams of people. There are things like organizational budgets and funding reports and things that they don't teach you in law school. And so, you know, so you have to find a way to build that kind of experience in addition to litigating cases day in and day out. And I think that's a challenge that we don't talk about enough. So there are increasingly more resources around. I went through an executive fellowship that's available for nonprofit leaders in California that had you know, we would meet once a month for a year, and once, you know, we would cover budgets, we would cover communications, we would cover management, we would cover these things that are not, you know, the bread and butter of the lawyer's day, but are critically important to be a good and responsible organizational leader. And so I think that taking the time to find out what resources are available to you and taking advantage of them, for those, you know, even just taking the time to identify what are the non-lawyer skills that I need to develop in order to be a good leader in my organization are really important. The Impact Fund is working on developing some of those right now. And we do a lot to provide trainings to the legal profession around, some of those basic skills that we don't spend quite enough time on in law school. So.
And Chris, can you tell us about some of the challenges of obtaining partnership at a law firm?
Sure. I'll just start off by saying that I've been a partner at this law firm for a little bit over 2 years, and I just sort of fell into it actually. I was thinking about joining a small plaintiff side practice, and I knew that there were some people who had started their own firm, and Adam and Steve in this case, and they were still in business. And so, I was basically sort of searching for a place to do interesting work, work with a good team of people who could sort of, carry the ball in so many respects, and also just sort of like maintain a sustainable lawyer lifestyle. Litigation can be quite grueling. And my father, who had an academic background, would take a sabbatical every couple of years. And so, part of the pitch to Adam and Steve was, hey, not only do we want to do interesting cases, be profitable, but I also want to make sure that we have a sustainable sort of law firm where we can sort of take time off as needed. And so, they thought that was fantastic. They thought that was a great way to sort of distinguish ourselves from other law firms, perhaps. And so, that's something that we've tried to incorporate here, that we are planning on incorporating here. No one's taken the sabbatical yet, but, that's the goal. But, to sort of echo, some of the themes and topics that, Bill, Lindsay, Steve has said, it's sort of like, and sort of working together with Adam and Steve and just, thinking about what it is to be a partner. A lot of it is just sort of quote unquote playing well with others, just being able to sort of build consensus, being able to sort of communicate your viewpoint, explain why it is you feel a certain way, perhaps even if you can't quite put your finger on it, being able to hear other people's feelings or frustrations or just sense it and just sort of like raise it in a sort of way and just sort of surface it and talk about it like in a reasonable adult, perhaps. Certainly there are considerations about, can this person bring in the business? Are they quote unquote carrying their weight? If not now, maybe later. But it's not everything, at least certainly not within our firm. And I imagine it's the same way at other law firms too. And I, turn to Lindsay and Bill about that sort of aspect of it as well. But, when someone is contributing to the firm in one or many different ways, that can either mean, sort of attracting and retaining talent, having a great work environment, it doesn't always have to be about dollars. And then just to sort of echo Stephen's point though about familiarity, sometimes it helps to have some sort of familiarity, obviously, with the people that you're working with and dealing with. Certainly, Adam used to work at the New York Attorney General's office. He and I have had mutual friends. One of his close friends lives in my apartment building. And so, we had friends in common. And so it certainly helped to sort of talk about, the shared things that we had in common. In addition to, for example, this is more for the Brooklyn people, the Park Slope Food Co-op, which is really fantastic.
My next question is for all of the speakers. Please feel free to chime in. What is it like to be an Asian American in your respective subfields? And also, another question that's related to that, how have things changed for Asian Americans in your subfield?
I'm just going to try to be brief because I go back so long that it might be more relevant to hear from the others. I'm class of 1974 from Columbia, and I was the first Asian American ever to apply for a job at the NAACP Legal Defense Fund. And when I was in California, in civil rights groups, there was Ed Chen up north. He's now a district court judge. And there was me in the South in Los Angeles. And for civil rights groups, that was it in California. And obviously there's been a tremendous change. And one of the nice things of in my career is to witness that change. I'll just say this, at the Legal Defense Fund, when another Asian American lawyer applied, and she had real credentials. She was a former Supreme Court clerk. Her name was Marina Shea. I think she teaches now. But I called up the boss, who at that point was Julius Chambers, a very illustrious litigator from North Carolina, and just asked him, am I a token? If he was from New York, I would have said, am I chopped chicken liver? But, you know, I wanted to convey to him that I was the one and only, and it didn't have to stay that way.
And so if I could jump on to the end of what Bill said, you know, I think the work that his generation did made such an incredible difference for me. So obviously I got to follow very closely in Bill's footsteps and have a mentor who was an Asian civil rights attorney. You know, I mean, it goes back to that, right? If you can see it, you can be it. It didn't feel impossible, and it didn't feel just as important for me to see it, you know, to work with people like Bill Lee, Mari Maeda, Donna Ryu. I mean, just these folks that have had careers of service committed to this movement. I think it was also really important for the people around me who were making decisions about me and about my leadership potential to see people like Bill and his cohort, right? So it didn't feel like they were taking a risk on me. I didn't have to be the first. And that has made an enormous difference in my career. And I don't know, I hope Bill knows how much of a difference he has made in our field. But I have certainly seen it in my own career. And so, you know, I think we are very lucky that he put in that application at LDF all those years ago.
Yeah, so, yeah, go ahead, Chris.
I was just going to tag in from Lindsay's point that when I was at a plaintiff's class action firm in San Francisco, I'd been there for a number of years, but I don't think there were that many Asian people. I'm trying to remember who the other Asian people were, but I'm really struggling. That is until Bill Lann Lee came along and joined the firm. And I was like, oh my God, wow, this guy is amazing. It's like, this is incredible. It's like, you know, this is actually something that's sort of, you know, as Lindsay said, sort of like you can imagine the possibilities, so to speak. And it was just sort of like, wow. And so I just wanted to sort of add on to that. Stephen.
Yeah, I'm just going to continue the pile on, as uncomfortable as this is for Bill. So I grew up in Southern California, and I think as I was going through high school and college, and it became clear that, you know, I wasn't going to become a doctor or like a mathematician. I was going to go in like a political science lawyer direction. You know, I remember when you know, Bill came to national prominence in the federal government, and it definitely, as Lindsay was saying, it makes you think a little bit. It makes you realize, like, oh, you know, it's possible. Like, you can actually try to achieve something out there that, you know, beforehand doesn't seem achievable, even though nobody has told you that. But it just sort of like is a very concrete sign of sort of the universe of possibilities expanding. You know, and I think, unfortunately, you know, we still need representatives. I mean, various communities do, but in all sorts of subfields. You know, I'll comment a little bit. You know, I'm in appellate litigation, which is a very, very small field of lawyers. And you tend to see the same repeat lawyers over and over again, you know, showing up in court, showing up in briefs. You know, I think in the Supreme Court bar, especially, it's a very small group, and it still makes news when, for example, like earlier this month, one of the few times when two women argued against each other in the Supreme Court, and everybody was like, oh my goodness, like, I cannot believe this is happening in the 21st century, right? And I think that there are still inroads to be made. I mean, there are a few, you know, Asian American advocates who have achieved prominence in the appellate world, Neil Katyal and some others, and it's like great that they're out there. You know, I will say a thing that's made a big difference too is having judges come from different communities and show up on the bench. I think, you know, some of this is posturing. People are always deferential to judges, right? But once that starts happening, people are like, oh, well, if I have to listen to this guy or this woman, like, you know, like maybe, you know, other people who look similarly, I don't think it's that surprising to see them in a leadership role. And I know I've never said this to their faces, but in the Second Circuit, if I'm in front of Judge Chin or Judge Park, I'm always like, you know, you might rule against me. I'm just glad to be here, like with you in the same room. So I think that's one way in which it's changed. But, you know, I think there's still progress to be made. And unfortunately, a lot of firsts that are yet to be broken in certain communities and certain sort of sub-litigation areas.
We
I
have
think that's, if I could just add one thing, Evelyn, I do just want to say, like, I completely agree with Stephen, and I don't by any means feel like our community has fully arrived. I think that, also I do think that it is notable that we have a lot of, like, sorry, it's morning in my house, coffee's being made. We do have a lot of, like, East Asian folks on the panel. And I think that our community has such deep diversity on so many different levels that, we are still part of this first wave that is making inroads into these positions of leadership in the legal community. And so we have a deep debt to the folks who came ahead of us. And, we also have a lot of work to do. And, and that role of modeling and mentorship, that is an extra thing that is on our plate in addition to being excellent lawyers. And so I look forward to the work. It's super exciting to me to mentor young attorneys and to help assist them in their careers, and to watch the diversity of our legal community grow. So we still have a lot of work to do, but I think we're up to the task.
Thanks, Lindsay. That's actually a great segue to another one of our next questions. And this question might be more helpful for the law students, young attorneys, or those wanting to make a career transition. It's not always easy finding a mentor who's a good fit. So this is just a general question for the panelists. Feel free to chime in. What sort of advice do you have on how to find a good mentor and how to build a relationship with a mentor?
Well, in my case, I wasn't looking for a mentor. And what I found, the reason I had a mentor with Jack was that, who passed away 2 years ago, I should say, was that he was someone that I felt I could emulate. It was sort of, he wasn't, there have been many brilliant people I've worked with, and he was not one of the most brilliant people. I don't consider myself very brilliant either, but he's a shy guy. He could rise to the occasion, and he had this incredible work ethic. And one of the most eye-opening things was one day when he showed me he was arguing a case in the Supreme Court, he showed me his notebook. And beside the outline of the argument, he had sat down and figured out every possible question that could be asked. And he had also figured out the questions that the other side would want to be asked. And he had answers. And he had the notebook tabbed so that, and he showed me how he did it. He would turn around, look down, and then go to the tab and then start talking. I mean, so I think a mentor can appear at many points in your life. And I think I would say if you had to choose a mentor, choose someone who you think you could be like, not someone who's so off the chart smart that, it's one of a kind. He or she is one of a kind,
And I know that on this panel, there are mentor-mentee relationships. Can any of you share your thoughts on the importance of serving as a mentor?
All right, guys, come on. So
Thank you, Lindsay.
We're all being too polite. So, I mean, I just think I think there is there's a lot of different forms that mentorship takes, right? Some is, I think I'm a mentor as well as a manager, right? So I'm trying to model for my team what it is to be a responsible attorney, what it is, to litigate with thoughtfulness and empathy, And then there are, so that's sort of like their day-to-day. There are informal mentorships, folks who have come and worked with us for a summer, and then, but they're really interested in our work. I've had a connection with them and will continue staying in touch. And if they need that phone call, when they put in a job application, or they want to know, what small firm life is like, or things like that, just being available and taking those calls when those other people need you. And I think one of the most important things I do for my mentees is I tell them, like, this is not rocket science, what we do, right? I am not brilliant. I work hard. I show up every day, and I believe in the work we do. And I really think that's all you need to be an excellent civil rights lawyer. There is plenty of work to be done. We are always trying to put ourselves out of a job. So, just showing up and being committed and doing the work. I think that doing, kind of trying to convey that just on a day-to-day basis, informally. But then there are also formal mentorship programs that I've participated in and gotten a lot out of it. Our local law school, UC Berkeley, runs a public interest fellowship, or a public interest mentorship program. And so I participated in that in the last year, and that was like very short term. They assigned a law student to me who had similar interests in the work as the work I was doing, and we spoke on the phone a few times. She was going through the fall interview program, and I was able to share my thoughts with her and make a couple of phone calls to help her out, even though we were kind of working in this more formal structure, but I could see very easily her commitment to doing workers' rights work. And so it was easy to say, I know this person, I know that person, let me see if I can just flag your application. And I think, I'm the first lawyer in my family, right? We were on one of our planning calls, we were joking about this, like, my parents have no idea what my job really is on a day-to-day basis. And so I think, like, I didn't have someone to do that for me. I had no idea how to network, how to make connections, how to kind of leverage, relationships. And I think just that little tiny bit that we can do to help someone else who's coming up, right, can make a huge difference. Like Stephen's like, oh, I found out that part of the reason why, my application was flagged was because there was a relationship in the office that benefited him. And I think that that's something that we have to get very comfortable doing. When I was young, I was like, no, I have to make it on my own merit. I have to have the best application. I have to have the best transcript, and that's how I'm going to get it. And that's a big part of it. But I think we also need to think of ourselves as a big community that is here to help each other, which also, kind of goes back to what we were saying earlier about, about making those inroads in our industry.
Thank you,
So,
Lindsay.
Mentorship, yes. I'm still looking for mentors in my life. I'm lucky to have great mentors in my life, and mentor relationships, big and small, I think can really make a huge, huge difference for the community around us.
Thank you, Lindsay.
And just very briefly, I mean, I agree with all of that. I think the two things I'll say very quickly is one, not every very good lawyer is a very good mentor. Lindsay was talking about different skill sets. Being a mentor is its own skill set, right? It's actually hard work, and you need somebody who is, and then this is not all that common, who's not so self-centered that they think about themselves all the time, but actually try to make an effort to look out for you, even if there's no discernible benefit to that. Those are sort of the best mentors. The second thing I'll say, I don't know that this is essential, but I think it makes that first part easier if there's if you like each other a lot. And that's one of the challenges here. I think I still remember when I was starting as a lawyer, and I was a summer, I was working at a law firm for the summer, and I was in this conversation with some law firm partners, and people started talking about boating off of Maryland, and I had no idea what they were talking about. And I think I use that example as I think people find connections in ways to establish something like an affectionate, non-work related relationship, and it's not easy to get there sometimes if you come from a different background or a different history, but there are ways to do so. And I think when you hit off with somebody and they like you and you like them and you respect each other, it makes it that much easier for them to think about you, and then to do what Lindsay was saying, to pick up the phone, advocate for you. It's not that they're just okay doing that, but that when they hear you want to go somewhere or you're interested in doing something, they're eager to help you. I think that's sort of the quality of the best mentors, and it's what mentors should be doing as well for their mentees.
Thank you, Stephen.
I was just going to chip in and agree with everything that's been said before. Finding a great mentor is like incredibly helpful. And I'll just sort of tag in that, a mentor doesn't necessarily have to be, in this case, an Asian attorney, for example, right? It could be, if anything, it could be, there's so many more other helpful, progressive-minded attorneys out there who want to sort of increase the diversity of the field, who recognize the sort of challenges being faced by Asian American attorneys, and want to sort of like help people along. And so certainly, I've certainly had a great relationship with I would consider one of my mentors who's over at the city attorney's office. And it's helpful that, he's maybe like 20 years ahead of me. He's seen and done a lot of different things. And it's just, sometimes when I have a problem about either just balancing the work-life relationship, or just work, or just, whatever it is, it's nice to have that sort of sounding board to sort of provide that sort of like wisdom as to like, it's going to be okay. It's going to be fine. And like, maybe here's something that you should consider. And it's, as Lindsay and Steve have sort of indicated, getting along with the person is really fantastic. It doesn't have to be the sort of competitive, cutthroat sort of environment that, sometimes lawyering can be. It can just be sort of like building a community, a stronger community.
And at this juncture, we have a few minutes left for Q&A. If you have a question for any of our panelists, kindly submit it using the Q&A feature in specific, not the chat box. We'll try our best to get through all of the questions submitted in the Q&A feature. We don't have that much time left. And our first question is, do any of the panelists want to comment about how best to manage cooperation with white allies in the struggle for equal rights? For example, in relation to the boycott some Black students at Harvard organized against Jack Greenberg when he taught a class there.
I think it was not just Jack Greenberg. I think it was Julius Chambers' class also. But I think we're in the situation of not turning down allies, period.
Yeah. Oh, go ahead, Lindsay. Sorry.
You go, Stephen.
Oh, well, one thing I was going to comment on is thinking about the audience too. I mean, one challenge we've been facing, again, in the appellate world, is that the circuit courts and the Supreme Court have been changing in composition. And so to Bill's point, I think that there are people out there who are interested in supporting, various lawsuits and various movements, but who have like maybe get a disproportionate share of like attention if they're able to come in and comment. And I think there's good and bad in this. One of the things that we are very aware of is trying to get together like a cross section to make it seem like, there's broad support for a particular argument or a particular claim that we're making. And it sometimes requires two things. One is like thinking a little bit more broadly about what arguments might appeal to people. And the other, and maybe others can comment on this, is persuading people to work together who are not traditional allies, and persuading them to some cause, like actually you both can get on the same brief, or at least on the same case. And that has been challenging, although I think lots of organizations have become much more flexible about that in the last few years.
The thing that I would add is just that, I think white allies then also carry a certain responsibility of their own. There is this idea that you can't name yourself as an ally. The community that you're supporting gets to say whether or not you're an ally. And so I think that it can be, and I think, I also think about this a lot in, in the work that we do around the Black community. Of course, Black Lives Matter, right? I'm not a member of that community, so I need to think responsibly about centering the voices of the people who have the lived experience, and how I can act, how I can leverage the resources that I have at my disposal in support of that movement that I believe in. And so that requires both, you know, I think making sure that we're able to think critically about the role of privilege, and both it's the, you know, the danger of it subsuming attention and time that should be devoted elsewhere, but also the ways in which it can support and help. But I, you know, I totally agree with Bill. I don't think we're really in a place where we can turn down true allies, or that there's any, you know, that there's a downside.
Yeah, go ahead, Bill.
Oh, sorry, Chris, but I agree with Stephen that unlikely allies are actually, in some ways, the best allies. I think the usage was the last administration, but I mean, when Trump was in office, President Trump, he did so many things that were departures from prior practice that there became this sub-industry within the Justice Department world, where you had former appointees from both parties together on amicus briefs pointing out departures. I thought that was very powerful. So, go ahead, Stephen. I mean, Chris, go ahead.
Yeah, you know, I guess in terms of just sort of working with white allies, I mean, I think that, you know, oftentimes you have to give the person, the white ally, you know, the opportunity, the chance, you know, the opportunity to sort of like step up and do, you know, what it is that many people would want them to do. And so just to have that sort of personal conversation with them is incredibly helpful. And so just looping back to this menthol lawsuit that we had brought on behalf of the African American Tobacco Control Leadership Council, you know, in sort of talking with them about, you know, bringing on additional co-plaintiffs, you know, we had a long conversation and series of conversations about like what it meant to bring on the American Medical Association, sort of like the voice of doctors. You know, the American Medical Association has a budget which is incredibly huge as compared to the African American Tobacco Control Leadership Council. And so we wanted to make sure that, you know, Val and Bill and Carol's voices were, you know, heard, we're still directing the litigation, that they were setting the tone. And so that required like a series of conversations, not only just, you know, not only with the African American Tobacco Control Group, but also with the American Medical Association and their lead attorney, who happened to be white, as well as their in-house counsel. And so, you know, they were incredibly respectful. They were incredibly open. They were open to work with us in whatever level. And I think just by having that, you know, coming to the table in the first instance, by sort of saying like, you know, here's the opportunity, here are the concerns, you know, is this something that we can work together on, and just sort of working through and talking through those concerns, I think was incredibly helpful and sort of helped build a level of trust that we all sort of like help set the tone for, you know, working together in a really productive way.
All right, well, that wraps it up for our Q&A session. And now we are coming to the end of the program. I'd like to thank our wonderful panelists, Bill, Stephen, Lindsay, and Chris, for taking the time out of their busy schedules to join us on a Saturday morning, and for their contributions to such an insightful, exciting, and inspiring discussion. Bill and Lindsay in particular have joined us from California with the 3-hour time difference. And thank you to Chris for chairing this program as well. On behalf of Albany, the panel speakers, and myself, thank you all for attending our program on achieving justice and equity through litigation at the 2001 Albany Fall Conference. This concludes the program. Thank you.